Welcome, Wendy, to the Legacy Lounge.
Thank you. It's very nice.
Well, thank you. We're really excited that you could join us today. I know you're busy, lots of activity in the estate planning arena now.
There is.
For those of you who don't know, Wendy Farner is the founder and partner of her own law firm, Farner Perrin. And I was remembering we go back a ways.
We do.
And we were fortunate enough to work together when you were at Fulbright, which is
Right.
now Norton Rose,
Right.
Fulbright. And every time there were tough issues that came up, and was working with people when you would just come on board,
Right. They were my senior.
they were your senior, but they would refer me to you for real technical issues and creative ways to accomplish things and just communicate with clients so well. And so that was a while back,
It was. We were children.
children, and we did some programs at Rice University. You were always so great as a teacher. And I remember one particular time when we were doing a program at Champions Forest Golf Club. And I think we had to rub two nickels together to get through the toll booth.
We did because there was no easy tag then. You had to have change.
Right.
We didn't have change.
We didn't have change. And I think we got there with a minute to spare.
I think so. Yeah.
Great days, though.
Those were fun times.
Yeah, fun times. And you've built an incredible practice. And, I've had the good fortune to work with you and work with you and clients. And we're really kind of coming out of what a lot of people are calling, this has been the platinum age of estate planning.
Right.
We've had this incredible exemption, and things are about to change. And I was wondering if you could just spend a few minutes talking about, what's a pretty seismic shift.
Right. So this dates back to 2017 when the Tax Act of 2017 passed in December. And what it did was double the estate tax exemption, but only applicable for tax years 2018 through 2025. So on January 1st, 2026, we're expecting the doubling of the estate tax exemption to sunset, and therefore it will fall in half again, back to its 2017 and prior levels. And so just for a little background on what the exemption is.
Thank you.
The estate tax currently is a flat 40%, and it applies on the transfer of wealth at death for an estate whose value exceeds what the exemption amount is. So that exemption amount is really the threshold that tells us when the estate tax kicks in. So currently, as we sit here today, our exemption against the estate tax is $13,610,000. That's the effect of the doubling. And it's indexing for inflation, so we don't exactly know what it'll be next year, and then what it'll be in 2026 when the sunset happens. But we anticipate.
But for a couple, you just double that, right?
You just double that because each taxpayer has that. So
So-
today, about 27.2.
27.2. Amazing.
Right.
Has there ever, except for 2010,
Right.
the 1 year where estate taxes were suspended, have we ever been even close to this exemption?
No, we're close. So, for decades, we had a $600,000 exemption back in the 80s and 90s.
That's right.
And then in the very late 90s, we started to get some slight increases. I mean, slight to 625,000, 650,000. Then we jumped up to $1 million in 2001. And then throughout that period, we had some increasing exemptions. We went to $1.5 million, $2 million, $3.5 million. Then we had the 1 year suspension in 2010. And then we went up in 2011 and 12 to $5 million. And we saw a similar thing in 2012 where we were expecting a sunset of what were then the Bush era tax cuts that had given this jump up from $1 million to $5 million. And we were expecting the $5 million to sunset back to $1 million come January 1st, 2013. But Congress did change the law that time, and so we continue to have the $5 million exemption. And in fact, that's what we have today. We have a $5 million exemption, indexing for inflation since 2011, doubled for tax years 2018 through 2025.
So it's that doubling.
It's the doubling that we're
That's
expecting to
eliminated.
lose. Right.
Okay.
Right.
And so we have the greatest exemption ever
Right.
that's about to be cut in half.
Right.
And the only other opportunity we have for gifting is the annual exclusion,
Correct.
and which is a use it or lose it, right?
Correct. So every year, everyone, each taxpayer can give away currently $18,000 to any number of recipients. Doesn't need to be family, though most people limit it to family.
I think you and I have mentioned to clients that it doesn't have to be family a few times, and no one's ever taken
No one
me
ever
up
gets
on that.
excited
Yeah,
about that.
I know.
We're happy to help them reduce their estate tax.
Yeah.
So yeah, $18,000 a year. If you don't use it in a calendar year for any individual, it just lapses, but you get another $18,000 the next year, and that's indexing for inflation too. And in fact, we already know that next year it's going to index to $19,000 a year.
Thanks. Okay.
Almost got there this year. It just fell shy of that. So we know with inflation where it is that it'll be $19,000 next year. So that's an annual sort of renewable coupon.
There's no change to that in the sunset,
There's
right?
no change
the
to that.
annual continues on the
That will
road
just
it's on.
continue and continue to index for inflation.
Okay.
And it's powerful. You know, people tend to discount it because $19,000 a year doesn't sound like a whole lot for the very high net worth individuals. But compounded over a child or grandchild's lifetime, it can be a very powerful estate planning tool also.
And when you include family and extended family,
Right.
you can really
You
leverage
can
that
move a lot of
quite a-
wealth.
quite a bit.
Exactly.
Yep.
Exactly.
So, with this incredible shift, I know you're getting busier, but even under any circumstances, sometimes people just put off estate planning. They
Right.
put off doing their wills. Why do you think that is?
Well, some of it's just human nature, procrastination, you know, the same reason I put off going to the dentist. But I think, you know, there's a little more to it because during the process, you're kind of facing your mortality, right? You're talking about what's going to happen to my assets when I die. How am I going to provide for my family? Who's going to get what? Sometimes that's a hard decision, and sometimes people don't always agree on that. You know, commonly people want to leave things for their spouse and then equally for their kids. But if there's any tension in sort of how things are going to be left, even tension in do we include charity or not? Do we include extended family? Do we include in-laws? Sometimes there's tension
In-laws
between a
or
couple.
outlaws.
Yes, in that sort of decision making. And so it's just natural, I think, to want to avoid, you know, having to face that.
And
So-
it's the unknown. I mean, how do you
It
plan
is.
for the unknown?
Exactly.
But I was reading an article by Stephen Lindbergh, who didn't realize it wasn't that long ago that we lost him, but he always talked about the annual gift exclusion as the little giant.
Right.
And I love that. But he was also talking about people not being able to talk about the concept because of the taboo in society and the unknown. But he also talked about how once people actually get their financial and estate planning in order, it kind of lifts a lot of weight off of them, and there's a real psychological groceries and benefits
Right.
to having that work done. Do you find that with your clients?
There is a lot of peace of mind, you know,
Yeah,
that people
right,
feel like
okay.
they've got things sort of tidied up for their family. They're not leaving things in disarray. And by contrast, sometimes if I have clients who have put things off and then they do wind up in a medical crisis, it's much harder to face those sorts of decisions and discussions when you do have someone who might be looking at a terminal illness, but then they've got to face it, you know, if they're
Well,
at
and
that
especially
point.
if they were two spouses that work together and now one of them is really not in the equation. They're not
Right.
well enough to really contribute to the planning. So
Right.
doing it early.
Doing
is
it early
obviously
is,
like everything else, I guess.
and you can always adjust it if things shift, if family circumstances shift, if financial circumstances shift, wills can always be redone. So you're not putting anything permanent in place.
That's a really good point, that we don't often think of wills as a revocable document, but they are.
Completely
They
revocable.
can be completely changed. Unlike some of the irrevocable documents out there,
Right.
a will can be changed.
At any time, as long as you,
Yeah.
continue to have sound mind. That's sort of the hurdle we need to
Yeah.
maintain.
Like to be able to jump over that one.
Exactly.
Right. Well, I think sometimes people think that they need to get everything in their mind in order before they put it on paper. And there might be squabbles between children. They wonder if their kids are going to spend it right. They wonder if they're going to share the toys.
Right.
And as you said, they may not know exactly where every asset goes, to which child and things like that. But there'll always be something that you can't tie down, but it's not a reason to not plan. Right.
In fact, sometimes I have clients in my office who come in to sign their wills and then feel indecisive about something. I'm not sure I got that right. Maybe I should hold off. Maybe I should reconsider. And I always encourage them, look, this will here that we have to sign is much closer to your objectives than having nothing in place or what you've had in place previously. So let's go ahead and sign this, and then you know that 9/10 of what you want is going to happen. For that other 1/10, where you're not sure if you want that to play out as it's written, consider that, continue to consider that, and we can always adjust that later. What is that saying? The perfect is the enemy of the good, right?
Yes.
You might not get it perfect.
I was just thinking about that.
But let's get it really good, and then we can move toward the perfect later.
Yeah. No, great point. And I think that a lot of people want everything to be tick and tied before they even put it in their will. So I think that's great advice, Wendy. I think if people just realize that it's not a permanent solution to everything. You'll never get everything perfect.
And you've got more time, so.
Yeah. On the sunset, do you think it's going to happen?
I do think it's going to happen,
Okay.
just because Congress doesn't have to do anything, and it happens. And we do tend to view Congress as not wanting to take a lot of decisive action in the next couple of years. We've got an election, then we've got a new Congress. So if nothing is done, if we can't get some agreement, the sunset's going to happen. I think it's probably a steeper climb to anticipate that Congress is going to come to some sort of agreement about how they want to adjust the estate tax if they're not just going to let the sunset phase in.
It's kind of the path of least resistance.
Right, exactly right.
But do you think there's some possibility that they might even look at reducing the exemption further? There's some talk out there about Republicans and Democrats can agree on a lower exemption easily.
I mean, they could. As a matter of fact, the Build Back Better Act, which was proposed and very close to passing in the fall of 2021, would have reduced the exemption at that point to $6 million, left it flat and not indexing for inflation.
That's the first time I had heard no indexing.
No indexing as a part of the Build Back Better. Now, that law didn't pass, but you may remember it was only one senator, Joe Manchin, who kept that from passing. So it was very close to passing, and that would have reduced the exemption even further than what we're going to see in the sunset. So.
Don't you think people underestimate the importance of that cost of living adjustment on there? Because if you peel that off, which might be innocuous to some people, you really will not see that grow.
Right. You're exactly right. And once you've used your exemption, you've used it.
Same with the annual exclusion, because it was $10,000 for so long, and now it's $18,000. What a difference! It's almost doubled.
And next year it'll be $19,000, right?
And $19,000 next year. Yeah. So I mean, and it's hard to argue against raising it with inflation where it's at. But
otherwise, it
still could happen.
It's just eroding if you're not raising it with inflation.
Right. Just walking backwards. there's a lot in the popular press about the sunset. Do you think that it's covered pretty well, or do you think a lot of people are aware of it?
I think in the higher net worth circles they
Okay.
are. And I think it's starting to even filter down to, a lot of mainstream media outlets are covering it. The Wall Street Journal covers it a fair amount.
Yep.
Forbes covers it a fair amount. So I think there's a good amount of awareness of it.
And so you have been getting more interest, and people are beginning to prioritize some of their estate planning documents?
Yeah, it was really when the calendar turned to 2024. In 2023, people weren't too excited about it, but come January, suddenly people thought, "Oh, I only have 2 years. I better start this process." Because depending on what sort of gifting and or trusts you may want to implement to take advantage of the exemption, it can take a year or year and a half or so to kind of set the stage for all that planning and get it accomplished. So it's not necessarily just writing a check for $26 million and being done with it. In fact, none of my clients do that. So it's usually a more involved process.
No, that's a really important point, because now we're sitting here at 1 year and 9 months.
Right.
And if you're saying it takes a year and a half, because there's no magic wand. It's usually
Right.
layering
Right.
ideas one on top of the other. And you are a master at explaining complex ideas simply, but it still takes time,
It
right?
does. Clients need to get comfortable with it, because the sorts of planning that we envision with giving away the exemption amount are irrevocable. And so I always tell my clients, I don't want you to have buyer's remorse. If it turns out that the sunset doesn't happen, which none of us knows what Congress is going to do. Trying to predict Congress is probably the most difficult thing on the planet. And so if the sunset doesn't happen, I always want my clients to feel satisfied that they did good planning that worked for their family regardless of the
Regardless.
tax outcome. And so they need to get their head into that. They need to get comfortable with it. And they need to make sure that whatever we set up in terms of trusts or partnerships are compatible with their family.
And that they make sense
and that they make
irrespective
sense.
of the
Exactly
sunset
right.
or whatever happens out there.
Exactly
Yeah.
right.
Sometimes people are concerned that if they go, because the issue now, right, is you'll forfeit giving above 6 million if we get to the
Correct.
sunset.
Probably 7 million. So it'll probably
7,
be
okay.
14 and a half when the sunset happens. It'll probably come down to 7 and a quarter, something
Okay.
like that.
And so you could forfeit that opportunity if you don't plan
Exactly,
now. That's
exactly.
the big
Right.
issue. Some people are concerned that there might be a clawback of that. Do you think that there's any truth to that rumor or that concern?
There was a lot of concern at first, say 2018 through 2020 or so. Then Congress did issue some regulations that
Okay.
indicated there will not be any clawback. So we're now quite comfortable that there won't be a clawback. So for people who give away, let's just say 14 million or 28 million as a married couple
couple?
next year, we're comfortable that that's out of their estate and that it won't be brought back in, as long as everything is drafted properly according to the IRS rules. But clawback's not a concern at this point.
Great. What are some of the techniques, and without going into a lot of detail, that can be used that makes sense for
Right.
people, but can save substantial taxes?
So as I mentioned, I never have clients who just want to write a $26 million check. That's never the case. Almost always, we're talking about using trusts. Either trusts for children or trusts for your spouse. Because when
Okay.
you're talking about giving away that much wealth, you usually want to put some parameters around how it can be spent, and trusts can do that. And also you want to put some protections around the assets, and trusts do that. So it's like we used to teach at Rice when we taught trusts. Think of the trust as 3 points on the triangle. So we've got the grantor as the first point, and the grantor is the person who creates the trust and sets forth the guidelines and the governing rules for how the trust is managed and dispersed. And then there's the trustee, who is the person who reads the trust agreement, manages the trust according to the terms set forth in the agreement. That's both managing the investments inside the trust and making disbursements as directed by the trust. And then, as we always used to say, our favorite spot on the triangle, the beneficiary, that's the person or the people who benefit from the trust, who get disbursements according to the guidelines set forth in the trust. So sometimes it can be something like, oh, the beneficiary is going to receive $3,000 a month. Or sometimes it can be the trustees or the beneficiary is going to receive whatever they need to provide for their support, maintenance, health, and education. Or sometimes it's going to be whatever the trustee thinks is in the beneficiary's best interests. So there's all sorts of ways that trust can be structured. And it's the trustee's role to administer that and make sure it's done properly. So when we're talking about significant wealth, 14 million, 28 million, even less than that, of course, is still very significant. We almost always want to use trusts so that we can make sure that the funds are handled properly and dispersed according to the wishes of the grantor. But also the trusts provide some additional protections.
Great, because I think sometimes people probably ask you, if I'm just trying to get assets to my kids or grandkids, why don't I just give them outright? Why do I need a trust?
Right, and some people feel like my kids are perfectly capable financially, they're mature, they can manage the trust on their own. And if that's the case, which oftentimes it is, then we oftentimes see the adult children acting as their own trustee. So now they're occupying two spots on the triangle. They're the trustee and the beneficiary. So they're managing everything, just like if they owned it outright. And then if they
And it's not every state where a child can be the trustee and the beneficiary, right?
I think in most states you can. The issue is that most states don't allow the grantor to also be the trustee or the beneficiary, which is a self-settled trust. But there are a few states that allow that, and that's a little bit untested as to how that's going to work. But some states do allow that. Do most states
allow the trustee to be the beneficiary as well?
Yes, most states do. Most states do. So that's pretty, that's pretty standard estate planning where the kids are mature enough and responsible enough to handle it. And a lot of my clients feel like their children are. And so then the trust isn't really so much providing that structure for someone else to manage for the kids or someone else to handle how the kids receive the funds. It's really providing the protections. And the protections really are threefold primarily. One is tax protection. So whatever's inside that trust is not only outside of the grantor's estate, the person who created the trust, we can also structure it so that it can be outside of the beneficiary's estate. So the beneficiary can use the trust funds as needed during his or her lifetime. Think of the child, spending as he needs or she needs. But if the child is successful in their own right, they might not need much of anything from the trust. And then the trust can grow and accumulate over their lifetime. And then whatever's in the trust at their death can pass to their own children with no estate tax, no matter how large the trust has grown.
So it's the coming out number that's tax-free, not just the number going in.
Exactly right. And we had a change to our trust law in Texas in 2021.
Oh, thank you. Good.
So that now these trusts can go on through the generations of a family for 300 years. And so that's roughly 8 to 10 generations that we can move wealth outside of our transfer tax system.
And it used to be about 120 roughly,
used to be about 100 to 120.
And so it's been more than tripled.
Right. So that's a terrific change to our trust law. Now, any generation might need it all and spend it down sooner.
Okay.
But if we have generations that, are successful in accumulating wealth, to the extent they're accumulating it in this trust outside of our transfer tax system, then it can move down estate tax-free for those 300 years.
Multiple generations. Now, some people, as soon as they hear the word generation skipping trust, are put off by it. because they
Right.
think they have to skip a generation.
Right, right. And their kids are really put off by it when they
Yeah,
hear it.
right.
Yes.
That's right. More so
Yeah.
even than the grantor. Okay.
Right.
But
Yeah.
it is a terrific tool, isn't it?
Yes, it is. And I always hesitate to use that term because it is a misnomer, as you
Right.
say. Um, but what I tell my clients is that we're not really skipping your kids. We're putting assets in trust for your kids, assuming that's their objective, and it usually is. And the kids could even spend it all if they need it, but to the extent the kids don't need it, then the assets in the trust can pass through to the next generation, and we're skipping taxes at the kids' generation. And now we can skip taxes at 8 to 10 generations. So that's really what the generation skipping refers to, is the skipping of taxes.
A tax skipping trust.
Exactly.
Yep.
Exactly.
So a lot of people don't know that there's also a generation skipping tax
There is.
in addition to the estate tax.
There is.
And I don't know if you remember this, but we taught a course at Rice, and there was an individual who had a retirement plan, was a New York resident, that had grown to about 18 million.
Oh my goodness. That does ring a bell.
It's been a while since we talked about this, but what was fascinating was this client ended up doing most of his work in New York because he was a New York resident, but he said that he knew his kids did not need that money because they were successful in their own right. So he made the grandchildren 100% beneficiary of that $18 million IRA. What are the tax implications of that?
Well, so there is an exemption against the estate. So it's an estate taxable transfer. So you have to use your estate tax exemption to apply against it first. And then it's also a generation skipping transfer. So you'd have to use your generation skipping exemption.
And the tax rate on generation skipping?
Also 40%,
40,
also a flat 40%. And then there's an income tax when the grandkids receive it. So
because you've never paid income tax on the money
Exactly.
going into that retirement plan.
Exactly. So if he had already used his estate and generation skipping exemptions elsewhere, which he may have done lifetime planning and used those exemptions, then you'd be looking at an estate tax of 40%. You'd look at a generation skipping tax of 40%. And then you'd be looking at, when the grandchildren receive it, income tax at whatever their income tax rate is. If he had estate and generation skipping exemptions to apply against the IRA, then only the amounts above the exemption would be subject to estate and generation skipping
But
tax.
if the total amount of the IRA was on top of the exemption,
Right.
I think we looked at the numbers and it was something like 2 million of the 18
Probably that's right.
was transferred after the
because he'd already used his exemptions.
used the
right.
exemption,
Yeah.
and he had estate, generation skipping,
And income.
and income.
Right. Yeah, that's not an effective strategy.
That one probably
No,
was not optimal. Yeah. Qualified plans are taxed rather heavily.
Right.
Have you seen or have you been doing anything different in terms of advising clients on what to do with retirement plan distributions? Or do you leave that to the advisor? Or what's your thought on that?
Yeah, I mean, we focus more on transferring the plan at death. So
Yeah, okay.
Occasionally clients will ask us about lifetime distributions, but usually the financial advisors are more equipped on those types of issues. The issue is, since we had the Secure Act pass in 2020, recipients of qualified retirement plans, including IRAs, now need to fully liquidate those plans or IRA funds within 10 years of the owner's death.
And they used to be able to liquidate them over their lifetime.
Over their lifetime. So there was this concept of the stretch IRA. And so if you had a 50-year-old beneficiary inheriting an IRA, they might have a 39-year life expectancy or something.
Rather
And so
than 10 years.
Exactly. And so in the first year, they only need to withdraw 139th. And then in the next year, 138th. So just small amounts coming out in the early years. And not until the beneficiary reaches their own, senior years would they need to start taking larger distributions. So those numbers played out really nicely because you're allowed to keep, in that context, you're allowed to keep most of the retirement fund intact, growing tax deferred for a good number of years. But now with that 10-year payout, you've lost that option to stretch over your lifetime. And so, a lot of people are less inclined to use things like trusts for IRAs because of the income tax burden associated
Even higher
with it.
taxes than a trust.
Mm-hmm.
And so I think there's just a human tendency to think that tax deferral,
Right.
just in and of itself, is good, but there are ways to optimize that distribution as opposed to just wait and pile it all up
Right.
in the highest tax rate.
Right.
But also avoiding pitfalls like making grandchildren beneficiaries
Right.
and just unintentionally having generation skipping taxes. You've talked a little bit about trust, but can you talk about the difference between a revocable trust and an irrevocable trust?
Oh, sure. Let me first just mention the two other benefits of trust. We
Thanks.
talked about tax benefits, but the other two non-tax benefits, and really a reason I think a lot of my clients choose to use trusts, are marriage or divorce protection and creditor protection as well. So if you leave inheritance to your children in trust, even if they're their own trustee, as long as we've got the appropriate language as to how distributions can be made from the trust, then the assets in the trust can be shielded in the event your child or grandchild divorces, or in the event that they ever have a lawsuit against them. Even if they need to go through a personal bankruptcy, that trust is insulated from reach.
Remember those years in the 80s where, there was a lot of real estate that probably
Right.
would have gone by the wayside had it not been in trust.
Right. Yeah, you're exactly
Yeah.
right. But in terms of the revocable versus irrevocable, so revocable trusts, as the name suggests, the grantor, the person creating the trust, can revoke it at any time. And so usually a revocable trust is set up as really a sort of probate alternative. It's really an alter ego for the grantor. So it's set up so that the grantor
Interesting.
or joint grantors, if it's husband and wife, are the lifetime trustees and beneficiaries. They can revoke or change the trust at any time, just like they could their will. They're still in charge of all the assets. They spend what they need. They can gift out of the trust to other people. So it's really just a different way to hold their own assets. And the benefit of having assets in a revocable trust is that then when you die, the trust agreement governs how the assets pass at your death rather than your will. And so if all of your assets are titled in the trust, then your will doesn't need to be probated because you don't really have any assets for it to operate on. And so for states where probate is difficult and expensive and time-consuming, you'll see almost everyone plan their estate through a revocable trust to avoid that difficult and expensive probate process. Those are states like California, New York, Massachusetts, Illinois, the usual culprits, But Texas has a very streamlined and inexpensive probate process. So sometimes I have clients who, notwithstanding that probate's not that difficult or expensive, still want to set things up to streamline it for their kids so that they don't have to go through any legal process.
But you have to catch it all
But you have to catch it all if you leave
and
one or two
retitle
things
everything
out.
to that.
Exactly.
And there are no estate tax savings with revocable
Correct.
trusts, right? And a
That's
lot
correct.
of people get that confused.
Right. So you can do estate tax planning through a revocable trust, just like you can do estate tax planning through a will. So you
Okay.
can save estate taxes, but no more estate taxes than you can also save through proper will planning. So it's really the probate avoidance that you're accomplishing.
Yep.
And then additionally, and this is where I would tend to recommend it, is if I have clients where we think there's going to be an incapacity down the road. And so we want to set up a succession of trustees to manage their assets if they become unable to manage them themselves. So that would be the early Alzheimer's diagnosis or early dementia. or something where we feel like, the day may come where they can't manage their own assets. So we want a successor trustee in place to step in and just seamlessly be able to manage their affairs for them without any difficulty. And so that's where I think for Texans, a revocable trust really makes sense.
Yeah, the incidence or the use with the aging population
Right.
makes it more sense than it used to be, because we used to talk about probate being so streamlined, but
Right.
really that care, the successor management and caretaking.
Right. And having
And
all
making
the
it
assets
easy.
available.
Right, and consolidating them.
Right.
And
right.
also, they're not a matter of public record, right?
Correct. Although, I guess it was about 10 years ago, maybe even a little longer, our legislature passed a new probate law that says you no longer need to file a probate inventory in the records of the estate.
Really?
And so now our executors, they still have
Wasn't
to
aware of that.
prepare a probate inventory, and they have to give it to the beneficiaries of the estate so that the beneficiaries can be assured that they received everything they were supposed to. But they no longer need to file that in the probate records. They can instead just file an affidavit in the probate records saying that they prepared the inventory and gave it to the beneficiaries. So you can keep your assets private now, even if you're in a probate process in Texas. What you can't keep private is the disposition in your will. And so the will is a public record. And so sometimes if I have clients who are disinheriting a child, or maybe if they're a public figure and they want to keep their dispositions private, we might do a revocable trust just so that nobody can go see what their will did. And I will say that when Barbara Bush died, I did go to her probate records because I was curious. She had a revocable trust, so I don't know.
She did,
Yeah.
so we don't know.
Her will said, I leave everything to my revocable trust. So that's all I knew.
We know there's a Kenny Bunkport, but what
We don't know
else,
who got it, right?
We don't know who got it. It's funny. A lot of times people look at the trustee role and they say, I think I can trust my kids, but I've got several kids. And they wonder whether they should consider an institutional trustee, a trust company. And I think that you've always been partial to having a family member involved in that. But what's your outlook on, institutional trusts versus family trustees?
I mean, I think it just depends if you've got qualified family members. So I see increasingly in my clients sort of a reluctance to turn things over to their kids at young ages. And by young, I mean under 40 or under 45. I think we've seen with each succeeding generation maybe a little more slowness toward maturity and financial independence.
A global pandemic,
A global
isolation,
pandemic, it's
and-
just so much craziness.
Right.
And people not sure that their kids are ready. And people don't always have siblings or family members who have comparable financial situations to theirs. A lot of my high net worth clients are self-made, and their siblings don't even appreciate how much wealth, my clients might have accumulated. So they don't want to call on them because they don't feel like there's enough sophistication there. So if there's a qualified family member who's reliable and has some financial sophistication, and not that they're going to be day trading the trust account or anything, or even managing it themselves, but have some aptitude in selecting the right financial advisors and bringing the right people on. If we've got people like that, then I think family makes a lot of sense. But increasingly, I see less willingness to go to family as trustee.
I've never had anyone be overjoyed about serving as a trustee, even a family member.
No, usually
or
it's
an executor.
And usually it's the matter of if the kids are at a point where they can do it, and if not, then you're right. We're looking more and more toward corporate trustees. Then.
And it's great if they're smart and they're not too busy, because sometimes the most successful kids don't have the time to take that on. But I've been looking to the executor role more, I think, than I used to. I used to think of that as, well, it's a temporary ad hoc position. Everything gets totaled up. But actually, it happens at a time that's probably the worst time for grief.
Right.
And it takes a lot of knowledge just about
Right.
titling and certain filings.
Mm-hmm.
And I really, used to think, and I used to listen to advice from specialists that would say, the executor role is just temporary. We can use a family member for that. We don't need professional help. Are you seeing that change at all with people?
Somewhat. I think there's still a little more reluctance to name a corporate executor.
To someone, the trust factor for, no pun intended, for
Right.
outside the family.
Right. And I think corporate executors tend to take a higher fee as a percentage than individuals will because it's a burst of work in a shorter time frame. And so I think
That's
people
true.
tend to push back, on what they perceive as maybe a little higher fee than there is for managing a trust. So, yeah, I do see a little more willingness to consider the corporate trustee in the executor role, but I think you're right. I still see a little more willingness to consider the corporate trustee for the trustee role than the executor
Just seems to
role.
be increasing a little bit lately. But, as you look at your practice, because you've worked many years now,
A few.
even though you're young, you've worked with very complex cases and high net worth families. Is there any case without betraying any thing that you wouldn't want to that's private? Is there an interesting case, one of the most interesting cases that you've worked on?
Oh, gosh, that is hard. Well, I think the one about the client who was not my client. I came in after the will was already probated, who left everything to the horse. That one always stands out.
You have to tell
Oh, that
about
was
that.
a great one.
You have to tell that story.
It was just an older woman who, lived on a ranch and had a horse and loved her horse and hated her family. She never married, she had no kids, and she had siblings and nieces and nephews, and they never got along. And she was just adamant that her family not receive anything, and so she went to a country lawyer, and he drafted a will that left everything in a trust for the horse. I mean, the problem was a horse is not a proper trust beneficiary. It actually needs to be a person.
That did not occur. This is
No.
why having a certified in estate and probate might come in handy.
So the gift under the will lapsed, what we call lapsed, because it wasn't a proper recipient.
Okay.
And so then the will really had no other beneficiaries, which means the will really wasn't leaving the assets anywhere. So then the intestate heirs come in, who are the dreaded nieces and nephews. So they bring a will contest. Texas A&M University was the remainder beneficiary of the trust. So this was about $25 million.
Interesting.
And it was back in the 90s, so especially a lot of money then, still a lot
$25
of money
million
now.
to the horse and trust.
And to maintain the ranch and the properties as long as the horse was going to live
alive.
there. And then when the horse died, whatever was left in the horse trust would go to Texas A&M. And so A&M, of course, joined in the litigation. The nieces and nephews joined, but the poor horse was not represented. And so the horse,
goodness.
well, how was the horse going to hire a lawyer,
Right.
And so
Oh, my gosh.
the horse wound up going to A&M. They wound up settling. They gave about half to the nieces and nephews, which I thought was way too much, but I wasn't, I'm not a litigator, so I wasn't in the litigation.
But half to
About
the family
half
that
to
she
the
did not
family
want to
that
get
she didn't
anything.
want to get and there was abundant evidence of that. And then half went to A&M, and A&M agreed to take the horse.
So it had nothing to do with her intentions.
Not
The
at
will
all.
got settled, but because it was not drafted properly.
Right.
Which
exactly
happens a lot.
right. Happens a lot,
Yeah.
unfortunately. Yeah.
So what questions should I have asked maybe about your practice or about estate planning that, is there anything I should have asked that I didn't?
I'm getting a lot of questions back on the on the topic of the sunset of, well, if the exemption, we're going to lose the doubled exemption. I call it the bonus exemption. We've got an extra bonus exemption for the next few years. If we're going to lose the bonus exemption in 2026, why don't I just give away $7 million now, and then I'll have my $7 million exemption when the sunset happens. I'll give away the part that I'm going to lose.
Just the amount you'd forfeit.
Exactly,
Okay.
exactly, and still keep the bonus. And there's a common misconception out there that can happen. But the estate tax laws don't permit that to happen. So you always use the bottom part of your exemption first and work up. And so if you were to give away $7 million, let's say, in the next 2 years, and then the sunset happened and the exemption came down to $7 million, you now would have used $7 million of your $7 million exemption, so you'd have zero left. So you're not really accomplishing any use of this bonus exemption until you give over, let's say, the $7 million, assuming that's where the sunset's
And that may be
land.
where the confusion on the clawback comes in.
That may contribute to it. You're
Yeah,
exactly
interesting.
right. Mm-hmm.
Interesting.
So it's actually much better. Sometimes I have clients who say, well, I'll give away $7 million, and then my spouse will give away $7 million, and we'll each keep $7 million, of our exemption. Well, actually, what you've done is just both given away your entire exemptions, and then neither of you has anything left. And so it would be far better for one spouse to give away $14 million, and now that spouse has used their full exemption, and when the sunset happens, they've got nothing left, just like would have been the case if they gave away $7 million. And then for the other spouse to do nothing, and then when the sunset happens, they've still got $7 million. So now as a married couple, they've moved $14 million out of their estate, and they've still got $7 million left for a total of 21, if you want to think of it that way.
And spousal lifetime access trusts come to mind, and a number of techniques that I've learned more about from you. So
Yeah, a lot of clients aren't ready to part with $14 million to their kids, and so there are strategies that can be employed where you can gift some or all of that into a spousal trust, where as long as you stay happily married, your spouse can access that trust, even trustee that trust. And so as a married couple, you can still have access to it.
One thing I forgot to ask about, I guess, has to do with estate tax payment. A lot of people do estate tax planning, but they may or may not do estate tax payment planning to the point where they actually earmark the assets that would be sold in the event of death. How do you approach that with clients?
I really look at it in terms of sort of a liquidity analysis. For clients who have a lot of liquidity, marketable securities, cash investments, you hope they don't have to sell assets when the market is down, but at least they've got the liquidity to do that if they need to pay estate taxes. Because estate taxes come due 9 months after someone dies. So you don't have a whole lot of time to sell real estate or sell businesses or things like that. If there is a lot of illiquidity, a concentration of wealth in real estate or business interests that are going to be hard to sell, and you might not want to sell in a fire sale after
Especially
mom or
when the
dad has
owner
died.
is
Right.
deceased.
Then looking at life insurance as a way to pay estate taxes is a really good solution if the clients are insurable. Because that can provide the liquidity at the time you need it, when the death happens.
And insurance is income tax free,
Correct.
but it is not estate tax free. If you die owning a large policy,
Right.
it inflates your estate. So how do you address that?
Almost always when my clients are getting life insurance to pay estate taxes, we'll put it in a life insurance trust. And my clients are
Irrevocable.
irrevocable.
Okay.
That's
Yeah.
right.
Okay.
And so you need to be certain, that you're going to be comfortable giving it away. But it's the one asset that my clients tend to be the most comfortable giving away, because it's not worth that much until they're dead,
Right.
So
No
they're
living
happy.
benefit
Go
to
ahead.
that.
Right, exactly. So commonly that's, an easy estate planning strategy that people readily see the benefit of, because they're comfortable giving away something they never intend to benefit from. And they can give it away while it has very low value because it's not matured yet. And then
Right.
as long as it's held in this life insurance trust where the grantors have no interest, then it's outside their estate for tax purposes, estate tax purposes, and the death benefit comes in income tax free.
Yep.
So if you've got 5 million, 10 million in a life insurance trust, your kids are going to net that after you're gone.
And it gives you some optionality to buy time, so you don't have to
Right.
sell assets quickly, I
Right.
guess.
Right.
And maybe even a little bit of a hedge against Congress changing their mind
That's true.
about
That's
certain
true.
techniques and tools.
That's true.
You've lectured a lot. You've been in study groups. You've been around. You're a leader. You've been around a lot of leaders. When you look at advice that you've gotten through the years to be as successful, as you are, is there any advice that you recall that made a difference in the best advice or the worst advice?
Yeah. I mean, probably the advice to try estate planning, because I thought I wanted to be a not even a probate litigator, just a litigator at first.
You did?
I did. I thought trials
That's a
were
world
all
of
exciting.
difference,
It's
right?
a world of difference. And my law school had a clinic where the students, with the oversight of seasoned lawyers, actually could represent clients in litigated matters. And so I did that clinic at law school, and it was a great experience, because I learned I don't like that. I don't want to do that.
You did not like it. What was it that you didn't like about
It
it?
is one corrupt system, and so I just didn't like all the gaming. It wasn't always about right or wrong. It was about who had the best lawyers, who threw the most money at it,
Interesting.
and all of that. And so I just didn't care for it at all. And so I thought, okay, well, I guess I'll do tax maybe, or corporate. So
Where you'd risk conflict with the IRS.
that's
that was
much
okay.
easier, much easier, right?
Funny.
And so I started out doing corporate tax as just a summer intern at Fulbright and Jaworski, and I liked it. I kind of liked the intellectual challenge. It's kind of like a puzzle, trying to figure out, okay, our clients want to achieve this result, and here's the rules we've got to navigate and maneuver, and how do we get there in the most tax efficient way? I liked that, but I didn't have any sense of the clients, because the clients were just corporate entities. And so that was just not rubbing me the right way. And I was talking to my mentor, or whatever they were called at the time, and she said, how are you liking tax? And I told her that, and she said, I think you might like estate planning, because it's also very tax driven. There's a lot of intellectual challenge. It's that same sort of puzzle solving, but you're working for individuals,
With
families,
individual
and
families.
couples, and so I tried it, and it was just a perfect fit, because I enjoy that whole human element. And I enjoy helping clients navigate difficult times with their family, and seeing them come through that and get to the other side of things.
So it was a perfect marriage
was a
between
good
tax
marriage, yeah.
and relationships with families.
So that was a very good piece of advice.
Yeah. Well, you have helped so many families, and I've learned a lot from you through the years, and I just really appreciate you coming today and sharing your knowledge, and just look forward to doing more together.
Same. Thank you for having me. I appreciate it.
Thanks, Wendy.
Sure thing.